Hi guys, welcome to another class of Law of Torts. Today in Law of Torts we are going to learn rule in Reliance versus Fletcher or strict liability and absolute liability. First of all, let's see what is strict liability. Strict liability means liability without the fault, that is without the intention or negligence of a person. Generally, a person is liable only for the wrong done by him intentionally or by negligence. But in certain cases, law holds a person liable for the harm done unintentionally and without negligence. This form of liability was first formulated in the case of Rylands versus Fletcher. ഇന്റൻഷനോ നെഗ്ലിജൻസോ ഇല്ലാത്ത ഒരു കേസിൽ ഒരാൾ ലയബിൾ ആക്കപ്പെടുന്നതിനെയാണ് സ്ട്രിക്റ്റ് ലയബിലിറ്റി എന്ന് പറയുന്നത്. Let's see what is the case of Rylands versus Fletcher. Fletcher was a lessee of the coal mine. Rylands constructed reservoir on the neighboring land of the coal mine to supply water to his mill. There were old disused shafts under the reservoir which communicated with the coal mine. The water flooded to the coal mine and damaged it. Rylands was an owner of a mill and Fletcher was a lessee of the coal mine. This coal mine was adjacent to the Rylands land. Rylands constructed a reservoir in his own land. But while constructing that reservoir, there were old disused shafts under the reservoir. Rylands was even not aware of the disused shafts. All the works were done by workers and independent contractors. These shafts communicated with the coal mine. The water flooded to the coal mine and damaged it. Here, Rylands had no intention to damage the coal mine. No negligence happened from his side. He just built a reservoir in his own land. The court held that Rylands was liable for the escape of water even in the absence of negligence or intention. റിലാൻസ് ഒരു മില്ലുടമയായിരുന്നു. ഫ്ലെച്ചർ ഒരു കോൾ മൈൻ, അതായത് കൽക്കരി ഖനി ലീസിനെടുത്ത് നടത്തുന്ന ഒരാളായിരുന്നു. ഈ റിലാൻസിൻ്റെ മില്ല് കൽക്കരി ഖനിയുടെ അഡ്ജസൻ്റ് ആയിട്ടുള്ള ലാൻഡിൽ തന്നെയായിരുന്നു. റിലാൻസ് അയാളുടെ മില്ലിലേക്ക് വാട്ടർ സപ്ലൈ ചെയ്യുന്നതിന് വേണ്ടിയിട്ട് അയാളുടെ സ്വന്തം ലാൻഡിൽ ഒരു റിസർവോയർ സ്ഥാപിച്ചു. ആ റിസർവോയറിൻ്റെ വർക്ക് നടത്തിയത് ഇൻഡിപെൻഡൻറ്റ് കോൺട്രാക്ടേഴ്സും വർക്കേഴ്സും ചേർന്ന് തന്നെയാണ്. അവരങ്ങനെ വർക്ക് ചെയ്യുമ്പോൾ ആ റിസർവോയറിന് അടിയിലായിട്ട് ഓൾഡ് ഡിസ്യൂസ്ഡ് ഷാഫ്റ്റ്സ് ഉണ്ടായിരുന്നു. ഈ വർക്കേഴ്സ് ആ ഷാഫ്റ്റ്സ് ഒന്നും അവിടുന്ന് റിമൂവ് ചെയ്യുകയോ അല്ലെങ്കിൽ അതൊന്ന് ബ്ലോക്ക് ചെയ്യുകയോ ഒന്നും ചെയ്തില്ല. അവർ റിസർവോയർ റെഡി ചെയ്തിട്ട് അതിനകത്ത് വാട്ടർ ഫിൽ ചെയ്തു. ആ വാട്ടർ കോൾ മൈനിലേക്ക് ഫ്ലഡായി കോൾ മൈനിന് ഡാമേജ് സംഭവിച്ചു. ഫ്ലെച്ചർ റിലാൻസിനെ സ്യൂ ചെയ്തു ഫോർ ഡാമേജസ്. ഇവിടെ കോൾ മൈൻ ഡാമേജ് സംഭവിച്ചതിൽ റിലാൻസിൻ്റെ ഇൻറ്റൻഷൻ ഇല്ല, നെഗ്ലിജൻസ് ഇല്ല. ബട്ട് ഈവൻ ദോ റിലാൻസ് വാസ് ഹെൽഡ് ലയബിൾ under the rule of strict liability. So first time this strict liability is invoked in Rylands versus Fletcher case. So it is known as rule in Rylands versus Fletcher. So what is the rule of Rylands versus Fletcher or rule of strict liability? If a person keeps anything in hand and if it escapes and does any damage, he is liable for all the natural consequences and losses due to its escape. Precautions and care are not the defense. That is, if a person keeps anything in his hand, he keeps it at his peril. He keeps it at his own risk. If that thing escapes and does any damage, even in the absence of negligence, that person is liable for all the natural consequences and losses due to its escape. Precautions and care are not defense. This is known as strict liability. Let's see what are the other things included under strict liability. Number 1, non-natural use of the land. Number 2, escape of anything dangerous like beasts, water, filth, stench, electricity, traction engine, or even a motor car with petrol in it. In all these cases, the liability of the occupier is strict liability. ഏതെങ്കിലും ഒരു ലാൻഡിൻ്റെ നോൺ നാച്ചുറൽ യൂസ്, അതുപോലെ തന്നെ മൃഗങ്ങളുടെയോ വാട്ടറിൻ്റെയോ മാലിന്യം, ദുർഗന്ധം, ഇലക്ട്രിസിറ്റി, ട്രാക്ഷൻ എഞ്ചിൻ, മോട്ടോർ കാർ, ഇവയുടെ എല്ലാം എസ്കേപ്പും സ്ട്രിക്റ്റ് ലയബിലിറ്റിയിൽ ഉൾപ്പെടുത്തിയിരിക്കുന്നു. In all these cases, the liability of the occupier is strict liability. Let's discuss two more case laws. In Snow vs. Whitehead, the defendant had put pipes in his house without connecting them to any drain, and hence water flowed to the adjacent house of the plaintiff and caused damage. The defendant was held liable under the rule in Reliance vs. Fletcher. In Ramnath vs. Kalanath, the defendant constructed a dam in his land and damage is done to the neighbor's property. Here, the defendant was held liable. Now, exceptions to the rule in Reliance vs. Fletcher. There are 7 exceptions to the rule in Reliance vs. Fletcher. Number 1, natural use of the land. Number 2, things naturally attached to the land. Number 3, act of God. Number 4, a wrongful act of a stranger. Number 5, plaintiff's own fault. Number 6, common benefit. And number 7, statutory authority. These are the 7 exceptions to the rule in Reliance vs. Fletcher. First of all, natural use of the land. For example, playing cricket in the cricket ground is a natural use of the land, and hence if anyone is injured due to the hit of the ball, he cannot recover damages. Things naturally attached to the land. The rule in Reliance vs. Fletcher is applicable only to the things which a person keeps in his hand. But if damages are caused by anything which is naturally attached to the land, the owner is not liable. In Noble vs. Harrison's, the plaintiff was injured by the fall of a branch from a tree in the defendant's land. The court held that the defendant was not liable according to the principle of Reliance vs. Fletcher. Number 3, act of God. If by supernatural power like lightning, flood, storm, etc., something escapes and causes damage, then the defendant is not held liable. In Nicholas vs. Marsland, the defendant constructed a dam and by a violent storm, water flooded out and injured the plaintiff's property. The court held that it was act of God and so the defendant was not liable. Number 4, a wrongful act of a stranger. If a third party wrongfully or intentionally causes any damage to the plaintiff, then the defendant was not liable. For example, Richard vs. Lothane. In this case, a third person deliberately blocked up the waste pipe of lavatory basin in the defendant's premises. The plaintiff's premises was flooded due to this, held that the defendant was not liable. Number 5, plaintiff's own fault. If the escape is due to the plaintiff's negligence or own fault, then the defendant is not liable. For example, Ponting vs. Knox. In this case, the plaintiff's horse escaped and ate some poisonous tree in the defendant's boundary and died. Plaintiff's horse escaped and ate some poisonous tree in the defendant's boundary and died. As the escape of the horse is due to plaintiff's own fault and not due to the defendant, he was not liable for compensation. Number 6, common benefit. If the escape is due to the consent of the plaintiff and it is for the common benefit of both the plaintiff and the defendant, then the defendant is not liable. For example, Carstairs vs. Taylor, the plaintiff and the defendant had stored water in the upper story. The defendant lived in the upper story. A rat made a hole in the water box and hence damage was caused to the plaintiff. On the above principle, as water is stored for the benefit of both, the defendant was not liable. Number 7, statutory authority. If the law has authorized the defendant to keep dangerous things, then the defendant is not liable for the loss due to the escape of things in the absence of negligence. Now we are entering to the last part of this topic. Rule in M.C Mehta versus Union of India, that is rule of absolute liability. By the M.C Mehta versus Union of India, first time in India, the rule of absolute liability invoked. What is absolute liability? Any enterprise or industry engaged in dangerous activity is strictly and absolutely liable to compensate persons affected by any harm or accident caused by it. This is absolute liability. Any enterprise or industry engaged in dangerous activity is strictly and absolutely liable. Strictly and absolutely liable to compensate persons affected by any harm or accident caused by it. The enterprise cannot escape by showing that there was no negligence. By the way, do you know what is this M.C Mehta versus Union of India case? It is also known as Bhopal tragedy case. യൂണിയൻ കാർബൈഡ് എന്ന് പറയുന്ന കമ്പനിയിൽ നിന്ന് മീഥൈൽ ഐസോസൈനേറ്റ് എന്ന വാതകം ലീക്കായി ഉണ്ടായ ഒരു ദുരന്തമാണ് ഭോപ്പാൽ ഗ്യാസ് ട്രാജഡി. സോ ആഫ്റ്റർ ദാറ്റ് ഇൻസിഡൻറ്റ് ഇൻവെസ്റ്റിഗേറ്റീവ് ഏജൻസി കണ്ടുപിടിച്ചു ആ ഒരു കമ്പനിയിൽ ആളുകളുടെ സേഫ്റ്റിക്കാകെ സ്വീകരിച്ചിരുന്ന ഒരു മെഷേഴ്സും വർക്കായിരുന്നില്ല എന്നുള്ളത്. അതിനുശേഷമാണ് ഇന്ത്യയിൽ ആദ്യമായിട്ട് അബ്സല്യൂട്ട് ലയബിലിറ്റി അപ്ലൈ ചെയ്തത്. Let's see what are the differences between the rule in Rylands versus Fletcher and rule in M.C Mehta versus Union of India. Rule in Rylands versus Fletcher is strict liability, whereas the rule in M.C Mehta versus Union of India is absolute liability. In Rylands versus Fletcher, need non-natural use of land by the defendant and escape of something from his land which causes damage, whereas in M.C Mehta cases, defendant should be engaged in dangerous activity. In Rylands versus Fletcher, persons within the premises cannot recover damages, whereas no difference between persons within the premises and outside the premises in M.C Mehta's cases. Number 4, the rule in Rylands versus Fletcher is strict but not absolute and it is subject to exceptions, but rule in M.C Mehta's case is absolute and subject to no exceptions. Number 5, ordinary or compensatory damages will be awarded in rule in Rylands versus Fletcher, whereas exemplary damages can be awarded in M.C Mehta's cases.